SJC-12663, Commonwealth v. Scott M. Zagwyn.
Ms. Oreste, good morning.
Good morning. May it please the court, Megan Oreste for the defendant, Scott Zagwyn. Today, my plan is to discuss 3 issues with you in this case. The first being the insufficient evidence on negligent operation charge. The next, the issue of the improper opinion testimony and its impact on this trial. And the last, the sufficiency of evidence on the operating under the influence charge. Turning to the negligent operation, the guilty verdict in this case went completely against the weight of the evidence. There was absolutely no evidence presented that the defendant drove in any manner so that the lives and safety of the public were in danger. He was pulled over for a civil infraction of having a single headlight out, which he was not aware. His driving was without defect. No speeding, no swerving, no moving across lines, no sudden braking. He pulled over properly, parked properly, and cooperated. The only evidence here went to the impairment element of the OUI charge. And I would argue that to infer negligent operation from the slight evidence of the impairment element on the OUI charge would blur the lines of these 2 separate charges and lessen the Commonwealth's burden to prove negligent operation as its own charge. In cases where impairment evidence was considered for negligent operation, there was ample other evidence other than the impairment alone. The Commonwealth points us to the Daly case, but Daly does not support that intoxication equates negligent operation. It basically tells us that it's one factor to be considered amongst other strong evidence. In the Daly case, the defendant crossed over 2 lanes of traffic, straddled the breakdown lane, and almost struck a large road sign. Here, there was 0 defect in Mr. Zagwyn's driving, such that anyone could have been in danger. The appeals court, in their decision on this...
He's driving with one light, right?
Yeah, he had a headlight out he was not aware of.
So he has a headlight out. It's 4 in the morning, right? Or it's very early in the morning, right? They've slept in the car, right?
Yep.
And also, I guess there's some reference to how dark the roads are. I don't know if that matters, but
There was some streetlights, I believe, on this road that he was driving. He actually was not observed driving for very long. He pulled out of a rotary and shortly thereafter was pulled over for the headlight out. The officer had seen the car
Or how long
pull
he
out.
was driving with that headlight out?
I don't think it matters how long he was driving. I think it matters whether there was any infraction in his driving. His driving was, there was no erratic, he didn't cross over any line, there was no swerving
Stop for the headlight being out?
for the headlight being out, which he was unaware.
That was okay, but you're not challenging that?
Nope.
okay.
I'm just challenging that evidence was insufficient to support negligent operation.
and none of the evidence that comes in about his own, he's got a fair number of disabilities, right?
Yes,
That
and I will
doesn't
talk
come-
about that under my next issue.
Well, but had that come in the first, that doesn't come in the Commonwealth case, right? If it did, wouldn't that be relevant to whether he's negligent about driving? He's got all these limitations. He can't hear very well, right? He's got one light out, can't hear very well.
Yeah.
He's taking a long drive after waking up in the middle of the night.
Yeah.
know.
The evidence did not come in the Commonwealth's case in chief, and so at the point where he asked for required finding, that evidence was not in front of the jury. And I would argue here that with negligent operation and OUI cases being tried jointly, it's plentiful. These cases come up all the time in the trial court.
Let me ask you this along those lines, different factual scenario than yours. If somebody is, say they have a .25 BT, and they're driving in the middle of the night on highway, undivided highway, and the lights are out, but they don't go over the line in either direction, but it's undivided highway, 3 in the morning, .25, and perfect operation. Is that operating negligently to endanger?
I would argue in that case there would be much more evidence than here because you have per se evidence of intoxication, where we do not have that in this case. Additionally, you have, I'm assuming from the facts, both headlights out, so we're driving completely in the dark. I would say that fact pattern has more evidence under negligent operation than we have here.
Is it enough?
I'm not sure.
Could a defect in a vehicle ever constitute this if the person drove fine? You know, so we have a huge snowstorm and I'm really lazy and I drive with a little peephole, right? And I drive down the road and I'm doing swell. Is that negligent operation? Because I'm endangering the safety of others potentially by having no peripheral vision?
I think the argument could be made for sure, and I think, again, that would be a fact pattern where we might have even more than we have in this case.
Right, and so what I'm trying to get, so we have one, I assume that the faulty license plate light is neither here nor there.
Yeah.
All right, so we're really talking about having one of the headlights out?
Yeah, and I would argue that because these cases are so plentiful and you almost always see negligent operation with an OUI charge at the trial court, that this case represents an opportunity for the court to clarify that some slight evidence under impairment elements of the other charge does not negate the Commonwealth's burden to prove the elements of negligent operation separately. I would argue the evidence here was wholly insufficient, and Mr. Zagwyn's timely motion for required findings should have been granted. And I respectfully ask this court to reverse the guilty verdict on negligent operation. The next issue is the improper opinion testimony. The arresting officer testified to the ultimate issue of guilt in this case. It prejudiced the defendant, swayed the jury's decision, and likely this trial would have had a different outcome without it. It's important in evaluating the testimony here to really look at the whole trial. Right from the beginning, this testimony comes in. The prosecutor in the opening statement tees it up, saying specifically to the jury, an officer will tell you the defendant was drunk when operating his vehicle. The Commonwealth might argue that that's just zealous advocacy, but it crossed the line and introduced an improper statement to the jury of testimony that should not have come in, that went to the heart of the case and the ultimate issue of guilt. Next, the arresting officer took the stand and stated it was his opinion the defendant was too intoxicated to operate the vehicle that night. Arguably, this is an even stronger statement than the one made in Canty, and it was from an officer where we know there's a heightened risk because studies show juries give greater weight to law enforcement testimony. Turning to the analysis this court set forth in Canty, we look at the first prong, the evidence. It was not overwhelming. The appeals court decision itself notes that the evidence was not overwhelming in this case. We have no erratic driving, no issues with parking, no alcohol in the vehicle. The defendant cooperated, all unlike the Canty case. I would argue we even have less here than Gallagher, where one appeals court justice dissented and said there wasn't overwhelming evidence in that case. Gallagher had admission, odor, red eyes, and slight infractions on field sobriety tests, but also had parking issues that we did not have here. What we have here is odor and admission to 2 beers several hours earlier the previous night, and slight infractions with the field sobriety test. But I would argue the field sobriety test evidence deteriorated when the defendant took his stand and testified about his disabilities. The testimony on the disabilities did not just counter the evidence the Commonwealth had provided. It showed that the evidence on the FSTs was completely unreliable because the FSTs are not designed to test somebody with the type of disabilities that Mr. Zagwyn has. In fact, the National Highway Training Safety Administration Manual that officers use in Massachusetts specifically states that people with leg and inner ear problems have difficulty with these tests. Mr. Zagwyn has a permanently disabled and disfigured leg. It's shorter than his other leg. He wears a brace at all times, and walking, never mind balancing, is a challenge. He does also suffer from severe hearing loss. He was a victim in the Boston Marathon bombing, which not only caused him not to be able to understand probably the directions fully for the test, but we all know, I think it's common knowledge, that hearing loss impacts balance and speech. He also suffers with severe PTSD. I ask this court, isn't it conclusively incorrect to say Mr. Zagwyn failed those field sobriety tests when he likely couldn't have passed them under perfect conditions given his disabilities?
What about the directions on the heel to toe and I can't remember maybe getting to W in the alphabet?
Yes.
That has nothing to do with disabilities, right?
Well, I would say that the understanding the directions and exactly how to do it, and I also think having the brace on his leg and not being able to balance in that position where you have your 2 feet.
I'm giving you that.
Okay.
Just not following the directions completely and not getting all the way through the alphabet.
Yeah,
that
I mean,
has
I guess
nothing-
you could say,
Right?
I'm sorry?
That has nothing to do with this.
Well, his speech is impacted, so, the officer may not have understood his finishing the alphabet. I think his speech comes into play there.
May not have, but we're taking, on a required finding, we're taking the evidence in light most favorable to the Commonwealth.
That's true. That's true. I would say that the evidence was still not overwhelming in this case, and I would also say that the jury instructions were wholly insufficient. They did not advise on how to handle the opinion, were not dispositive, did not tell the jury the witness's opinions were not dispositive, did not give the equality instruction even though we had a retired officer on the field, and did not tell the jury what their job was as a whole.
Can I ask you, get back to the defective equipment question?
Yeah.
Do you think that there are some, and putting your client aside, right? Do you think there are some defective equipment cases which could constitute operating to endanger? Because you don't have to prove that the person did in fact, right, operate to endanger, it's that they might. But do you think a defective equipment case or example could rise to this crime?
I've done a lot of research on and read all the recent cases on it, and I have not seen a negligent operation case where there wasn't some infraction in the driving. I think there's an argument to be made if you were driving with a car that was definitely, so broken that it was a danger to be driving it. I think there is some argument there, but I have not seen that in the case law.
All right, thank you.
Thank you.
Ms. Carey?
Good morning. May it please the court. Elizabeth Carey on behalf of the Commonwealth. Applying the Lattimore standard, the evidence was sufficient for a rational trier of fact to find the defendant guilty beyond a reasonable doubt of both OUI and negligent operation. Turning to the issue of negligent operation, the defendant had stipulated to everything except the negligence piece, the operating to endanger piece. He was driving at 2:40 in the morning. He was driving without both headlights functioning and was traveling on dark roads. We heard from the police officer that at roadside he needed to use his lights to illuminate the area, that there were a few street lights, but that it was otherwise dark. He told the officer that he had been going from
Not
Hyannis.
enough. Say he wasn't drinking. He's got one headlight and he's traveling on dark roads on the Cape. Is that negligent operation?
I think in this case it is. We have a high level of intoxication in this case.
Well, okay, so
But we were assuming he's not intoxicated, I think. Isn't that the
Assuming he's-
question?
Assuming he's not intoxicated, I think that makes this case significantly weaker because we can consider his level, or we can consider his intoxication as well as his level of intoxication towards the negligent operation. That's what makes the Commonwealth's case so strong. We do have the additional factors that it's a dark road, that he's driving at night, it's 2:40 in the morning, and these
But he's also
support-
doing a good job driving. Does that matter? I mean, he's staying in the lanes, he's not swerving, he's following the speed limit. He's a good drunk driver.
I think these are factors to consider when presenting it to the jury, but by all means are not conclusive that he was not operating negligently. I would turn the court back to the factors that we have, that he was so
Is there a
intoxicated.
case, what's the best case you've got closest in terms of facts to this? Because we have a lot of cases where we combine OUI and driving and negligent operation. What case is most like this one?
I would direct the court to Commonwealth v. Daley. We do have a lot of cases that tend to discuss the factors of operation separately from that of OUI, even though we can rely on the
Like
indicators.
Daly, I'm just guessing, was he swerving? Was he?
He did. He crossed over, I believe, the fog line on several occasions and was traveling in the breakdown lane as well, is my recollection of Daley.
And what we asked counsel, and the same question to you, have you found cases in operating to endanger that don't involve an observation of mark lane violations or some type of erratic behavior?
Simply
conduct?
driving alone I have not come across a case where it's simply an equipment violation.
So is it your view that if somebody is driving drunk, that is by itself sufficient to say they are negligently operating the vehicle?
I don't think that would be enough, simply because that starts to get into the point where negligent operation would effectively become a lesser included. I would direct the court to Commonwealth v. Woods, where there's a little bit of a discussion about where you are not having to present the same elements, essentially, that the OUI requires the evidence of intoxication, the negligent operation, operating to endanger. If the Commonwealth were solely to rely on evidence of intoxication, I think that would put it more into the realm of being more of a duplicative offense.
So what more do you need? If you have a person who is driving under the influence, is charged and convicted of that charge, what else must they do to rise to the level of negligent operation?
I think having the additional factors of driving late at night.
Driving late
with
at
a-
night, is that sufficient by itself?
No, not sufficient by itself, but with a headlight out, driving late at night, I think a long distance, I think those factors together, along with the level of intoxication that this individual had, is negligent. It would have potentially endangered the lives and safety of the public.
In the case in chief, what was the evidence as to how long they had been driving with only one light?
It was a brief distance, I believe it was a mile and a half was what the officer
So is a
indicated.
mile and a half sufficient? Or are you taking into account what I guess was later learned about how far he intended to go?
I suppose how far he intended to go, but I also recognize that it is the act itself that is the negligence. It's not necessarily how long he's been driving.
So driving a mile or mile and a half with one headlight on a dark night suffices if you are drunk?
Yes, would be my argument,
What
these
about-
factors combined.
What about the lazy person who does the peephole in the blizzard?
I think in those circumstances, that is negligence.
That's
That-
operating to endanger?
That would be operating to endanger because you have to take into account the elements around you, all of the circumstances. And although normally looking through your windshield would be sufficient where you have the snow and you're unable to operate your motor vehicle in a way that's safe for the public, that would be negligence.
And if you're not drunk and simply driving with only one light, is that negligent operation?
I would think in a vacuum, potentially not. If there are other elements going on around you, if it, perhaps if it were a situation where you had a snowstorm, perhaps if it
No,
was.
just, there's no indication of a snowstorm here, just basically, you're driving at night with one light, which itself is a civil violation. Is that suffice to say you're under arrest for negligent operation?
I would say no, because we have the civil infraction. If there are other factors that sort of present themselves and elevate it to the level of a criminal infraction, then yes. But standing alone, simply having your headlight out, I don't think would suffice to raise it to the level of now criminal from what was a civil infraction.
Well, we all remember from law school that negligence in the air will not do. So don't we need something, is there any case that we've ever had, looking at it the other way, that has said that just having something that would constitute a breach, like the not scraping off the ice, as Justice Gaziano suggested, or having a headlight out, that isn't enough. But the case comes out the other way and says that is not enough for operating negligently to endanger.
No, I wasn't able to come across cases dealing basically head-on with
Press
this
this issue either way yet.
That's my understanding. I was unable to find anything.
Okay.
Correct. If there are no further questions, I'll rest on my brief.
Okay, thank you.
Thank you.